Investigator Corporal Kitchens, inside that trailer, you were asked just a few moments ago on cross-examination whether you performed any testing to determine if there was a presence of semen or bodily fluids or DNA. Would you expect to find the defendant McNabb's DNA, semen, bodily fluids in that trailer where he lived?
Sure, along with fingerprints or anything else. It's where he lived. That's where his items are going to be found there.
And in fact, if he, in an interview, told Investigator Alexander that he and Cortney had sex on that couch just hours before the baby went missing, then you certainly would expect, it's not beyond the realm of possibility, that there would be his DNA there in that house.
That's correct.
And as Cortney's DNA should be in that house too. She lives there, right?
That's correct.
All right. Now, you were asked whether or not you checked for blood or semen on the baby liner. Was it apparent to you that there was not blood stains on the baby liner?
I did not see any type of stains of any type.
Okay. Now, semen on the baby liner, this was not a sexual assault investigation, was it?
No, it was a missing or kidnapped child case at the beginning.
You didn't learn from, or did you learn from Investigator Alexander and Tommy Davis, the coroner, that after the autopsy it was learned that there was some sexual assault on this baby, did you?
No, I was not.
So would you check to see if there was semen on a baby liner?
No,
unless it's a sexual assault investigation?
There would be no reason to, no.
But since this is the child that belongs to these two defendants, would it not be expected that their trace DNA would be on that blanket if there were any DNA to be found? Most logically, putting on our common sense hat and putting off crime scene hat, would it not be very logical that their DNA would be on that liner?
Sure, just like my DNA would be found at my house.
So that evidence would neither confirm that they were responsible for their child's death, nor would it exclude them.
That's correct.
Now, with the camo jacket and the hookah and the rolling papers and the wallet and everything that was found out there in the woods, and even with the shoes that were found the day before, if the defendant, in an interview with Investigator Alexander, connects himself to all of those items, would it not be something that you would expect that you would find, again, his evidence on?
That's correct.
Would it be necessary to test those items to determine who brought them to the woods if the defendant McNabb admitted to Investigator Alexander that he's the one who brought those items to the wood?
No, there would be no reason to do any testing.
Now, there's a camo t-shirt and a blue and black pair of camouflage boxers and a blue starter shirt inside of that bag. Is that correct?
That's correct.
You were just asked whether or not you tested any of those items. You sent them off to the crime lab,
That's
right?
correct.
And you were just asked whether they were tested to determine if it was the child's blood or if it was the perpetrator's blood. This 14-day-old baby died from blunt force trauma. Is that correct?
From my understanding, yes.
Is there any case that you've ever worked as a crime scene investigator where a 14-day-old baby inflicts defensive wounds on their killer and would leave perpetrator blood inside of a bag?
No.
Would you expect that any perpetrator who killed this child would have left their blood on the child's blanket?
Only if they've got cut in the process of removing.
If the defendant admits, defendant McNabb admits that he owned that bag, or a red and blue Nike Air Jordan drawstring bag, and Cortney Bell also says the defendant owned a drawstring bag that looks identical to the one found there in the woods, would you need to test it to see whether or not the defendant's DNA was on that bag?
No, I would not.
Would you use your common sense and realize that that bag...
Objection, Your Honor, is leading.
Okay.
Also, Judge, if you could keep the defendants straight, she keeps referring to defendant.
Well, every time she's done that, she's then corrected herself and pointed out which.
On the last one, I don't know. I may have missed it.
Don't know that she finished her last question before the objection started coming. So let's let her finish.
Yes, sir.
If the defendant owned that bag, the defendant McNabb, would you need to test that bag to determine whether or not his DNA was on the bag?
No, I would not.
Given the fact that the bag was out there in the woods, and you mentioned that there was raining would you expect that there would be trace evidence or DNA necessarily on that bag?
It's possible, however, the rain could have diluted it down so it would not have been identifiable.
When you're investigating crime scenes, do you have to assign some level of plausibility to a theory before you just start testing things?
Sure we do.
So, in theory, if you went into that trailer, in theory, in any crime scene, you could swab with a Q-tip every single square inch of an area looking for whatever evidence might be there. Is that correct?
That's correct.
Did you contemplate that somebody might have broken into this trailer and kidnapped the kid and took the baby out there and killed it in the woods?
Due to the fact that there was no forced entry noted on any window or door of the trailer, no, that did not. It did not appear to be plausible at that time that somebody had broke in and kidnapped that child.
Thank you. That's all that I have, Judge.
All right, thank you, Judge.